Hello and welcome to Parley from the Hindu, a weekly podcast that discusses current affairs with two subject experts. I'm Kunal Shankar, your host for this week's episode. Discussions are ongoing with India's bureaucracy talking about ways to amend both the country's nuclear liability framework, which is the Civil Liability for Nuclear Damages Act or the CLNDA, and the 1962 Atomic Energy Act to allow private companies to build and operate nuclear energy producing facilities. But this move is also part of a broader strategy to expand India's nuclear energy capacity from the current 8 gigawatts to 100 gigawatts by 2047, aligning with the country's clean energy goals. Now, the CLNDA, the Nuclear Liability Framework, as I had mentioned earlier, was enacted by India in 2010, and it includes provisions for supplier liability, which gained renewed global attention following the Fukushima nuclear disaster in Japan in 2011, triggered by a tsunami. India's CLNDA is unique in that it explicitly allows for operators of a nuclear facility to seek recourse against suppliers in case of defective equipment or services, something most international nuclear liability conventions like the CSE or the Paris Convention do not allow. There have been both support for these amendments and criticism against them. To discuss this, I am now joined by Dr. Ashley Tellis and D. Raghunandan. Dr. Tellis is the Tata Chair for Strategic Affairs and is a senior fellow at the Carnegie Endowment for International Peace in Washington, D.C. He specializes in international security and U.S. foreign policy with a focus on Asia. He's a former U.S. diplomat and he played a key role in the India-U.S. Civil Nuclear Agreement in 2008. Dr. Raghunandan is a science activist and former president of the All India People Science Network, affiliated with the Delhi Science Forum. He also directs the Center for Technology and Development, which focuses on sustainable and equitable technological solutions. Welcome to you both for on this show.
Thank you. Thank you, Kunal. Pleasure to be here.
Great. So let's begin. Let me begin right at with the first question. Do you support the Modi government's decision to amend the AEA and the CLNDA? Let's begin with you, Dr. Tellis.
Well, strictly speaking, I should not have an opinion on the subject because it's an Indian decision. And while I cheer the Prime Minister's decision to move the amendments to the Atomic Energy Act and the Civil Liability Act, I do so simply as an observer. I don't have a stake in this fight because I'm not a citizen of India. But the point I would make is this. If India has set for itself the goal of expanding nuclear energy, then in my judgment, it cannot reach that goal, especially the more ambitious goals that have been articulated in recent years. It cannot meet that goal without expanding the domestic capacity to build nuclear reactors in country. By all accounts, India is going to have significant constraints in the rapid expansion of that domestic capacity. So, if you are looking at a 100-year timeline, maybe India will be able to assemble the indigenous capabilities to build the reactors that it wants to build. But if you're talking of a timeline that is more in the region of, say, 20
20
years,
years. Yeah,
right?
yeah,
Then
yeah.
I think you have to supplement those indigenous capabilities with essentially foreign participation. And this is where you run up against the roadblock, where current Indian law, because of the way the liability obligations are structured, essentially prevents foreign participation in the sector. And so, from my vantage point, if India has the goal of expanding nuclear energy on the timelines that it has set for itself, then I think there is no alternative but to move the amendments that the Modi government is contemplating.
Right.
This, of course, presumes, that there are affirmative answers to many other questions, right? Which is whether nuclear energy is the right energy source that India should pursue, and so on and so forth. I don't want to get into those discussions because I think those are internal discussions to India. So I
Right,
have a
right,
purely instrumental logic in this. If you want
right.
to reach those goals, you have to make these changes. If I may just add an asterisk, which is a more personal asterisk, the imagined future that we had when we negotiated the US India civil nuclear deal
Yes.
was that foreign companies of every stripe, not just American, would participate in India's nuclear renaissance. And that dream, of course, has been frustrated by the legal evolution in the liability regime in India since 2010. And so, from a purely personal perspective, if I would like to see that ambition realized to have greater cooperation. And so I would, from that point of view, cheer the Prime Minister on with respect to getting these amendments done.
Great, absolutely. I think that that's a great introduction setup for this conversation. Raghu, your response to that?
My view is I think the idea of amending the laws in order to attract foreign investment, in order to expand nuclear power generation capacity in India, is
Yeah,
based on two flawed arguments or assumptions. The first is that the roadblock to expansion of nuclear power is essentially one of investment. That's the main block. If you had more investment, you'd be able to expand.
right.
And that you're not able to attract investment because you've got a legal framework which inhibits investment. And that is my second problem with this, which is that no major nuclear supplier country has shown domestically any capacity to expand at the rate at which we assume that India will expand in the coming years. We have not seen that happen in the US. We have not seen that happen in France. Britain does not have much of capacity anyway. Japan is on a slow track. Only perhaps China today has the capacity to expand at scale and at rate. And I don't see major Chinese investment coming into India to expand nuclear power generation. So even if we assume that you make changes to the Indian legal framework, will that really enable fresh investment coming in, especially from the US? Because there is no comparable US trend of expansion of nuclear energy in the US to show that any major American company or corporation has that kind of capacity. Either GE US is now GE Hitachi. Westinghouse has filed for bankruptcy and is owned by a Canadian company. And what happens to that with Trump's tariffs is another question altogether. So I
Yeah.
don't see that trend in the US. And funnily enough, neither France nor Russia, who are interested in expanding in India, has ever asked for a change in Indian law. So that doesn't seem to inhibit them. So this seems to me to be a purely American problem. And I don't see any major American company showing a major capability or an inclination for such expansion of scale, like Ashley was saying. If you're really looking at expanding to 100,000 megawatts, that's a tall ask to do. So, to my mind, if we are looking for expansion, I personally see it, realistically speaking, as coming essentially from domestic sources with maybe a little assistance or co-investment projects from a couple of countries, maybe Russia, maybe France. And I don't see the nuclear regulatory and legal framework in India as a major obstacle here at all.
That's an interesting position. It's so to sum up, you're saying the investment, the really high capital cost, which is really one of the inhibitors, by most estimates, per gigawatt of nuclear energy production is about 7 to 10 billion US dollars, so about 40 to 60,000 crores of Indian rupees. That is not an inhibitor in your view. And you are saying it's interesting. The other thing that you pointed out was France as a country may not have objected, but it is known that the Jetapur power plant project, which Électricité de France, the French company which is associated through Areva, the nuclear power generation company, which has been contracted to build those nuclear power facilities in Jaitapur in Maharashtra, that has not really gone forward for several years now. And the main objection that they're citing there is the liability clause, which is the other point which you're saying the countries may not be objecting, but it appears that the production generation companies are objecting to it, aren't they?
Let me just add, my main point is not that the investment quantum is not the obstacle. Investment, of course, will be required, and the investment will come if the investor thinks he will get returns on those
Right, which
investments,
is an
which
important
is okay,
business
which is
position.
fair
Yes,
enough.
yeah,
That's all right.
yeah.
The issue of liability comes up because it looks as if the worry is that if I invest and something goes wrong, then I'm going to
Yeah.
be held liable. The question is, in any other circumstance, any other equipment supplier accepts liability. Why is it not applicable in this case, or at least some sharing of liability or anything like that? The very idea that you invest and not take liability leaves open the suspicion that you want to come in, throw the money, and go and leave everything else to the operator and the country, the host country, to then look after any problems that arise. It's now your problem, I'm going. That seems to be the problem. And let me just add two small points, which is that in 2012, the then UPA government had a proposal to amend the nuclear liability laws in order to generate investment, etc. And at that time, the NDA, which is currently leading the government, had objected on precisely the grounds that you are allowing a multinational or somebody to invest and get away with liability. And they had cited the Bhopal gas tragedy as
As a
an
yeah,
argument, which is what we keep citing. We've been involved with Bhopal right from day one, and we are even today mired in the courts on Bhopal because Dow has gone and is having its own thing, and now the country is having to bear the cost even 45 years after the gas disaster. So that is, I think, is the problem, that there cannot be a situation where you have this kind of carte blanche for a company who manufactures the equipment to say, I have no liability once I hand over the thing to you and you sign saying, yes, I've received this machine in good order. After that, I can go. And if there is a manufacturing defect discovered tomorrow, there is no liability. So that to me seems to be the major concern. But my second point is that I don't see any US company today as also not question of investment, as having the capability to do a rapid expansion of nuclear power. Who is going to, which US company is going to set up, let's say, 10 nuclear power plants in India over the next 5 years? I can't see
right.
anybody. So where is this? If you say there's a demand from the Indian side, where is the supply side coming from for which we think we should loosen these regulations? I don't see that supply side.
That's a very interesting point. Doctor, it's a two-part question. One is, as Raghunandan pointed out, one is the fact that the current NDA government, which was in opposition in 2012, raised the fact that the civil nuclear liability framework must not be amended to not include suppliers because they did cite, as he pointed out, the Bhopal gas tragedy, which is it is true that it has been mired in quotes for nearly half a century, and of course, it also was right after the
Fukushima.
Fukushima tragedy in Japan, and the public discourse in India very much was animated. I'm sure you followed this quite closely, and it was decided that given these issues, suppliers cannot be not asked to bear any cost at all, because in any case the civil nuclear liability framework doesn't entirely give them an unlimited amount. There is a sort of a clause of just when and how much. So it is true, as I'd begun the podcast, it is very true that India is unique because no other nation has sort of framed the supplier liability at all. But do you think that is really the impediment here? Several people have argued this. And is it right to seek an amendment to that? The second question is, are global nuclear power producing companies quite up to setting up shop here? I do know that in the US there's been renewed interest on nuclear energy as well, because of Microsoft and several, particularly Microsoft, are talking about how it wants to deploy nuclear power to attain its net zero sort of goals, and particularly to use data center and other sort of data driven energy guzzlers, which really what they are, deployment with nuclear power. So, what's the scenario there, and are they really up to the task of setting up?
So let me answer both those in sequence, right? So to the first question, I think the Indian nuclear liability law is a genuine impediment to foreign participation in the sector. And I would just factually point out the statement that you made in response to Raghu's point, which is for the French, for the Japanese, and for the United States, all companies from all three countries have basically said they cannot enter the market as long as the current law stands. Now, Russia is a very interesting case because Rosatom is a parastatal, and therefore, in effect, in theory, the Russians would assume sovereign liability as opposed to the liability of a particular company.
Right,
But
right,
what India did, but even Rosatom, despite being a parastatal, refused to accept India's liability law. And what India did was it indemnified Rosatom through a contractual agreement. Now, the history and the sequencing here is important. They reached the contractual agreement in 2008 before the liability law was passed. So there was no prohibition against indemnification through contract. So the Russians were lucky because they essentially jumped in with both feet before the liability law was passed. India was able to indemnify them through a private contract. But after 2010, that is not an option available to the Indian government because to indemnify through a private contract would violate parliamentary intention in passing the law.
right.
So essentially, anyone who's attempting to enter the market after 2010 faces this insurmountable obstacle that the Russians did not have. Now, let me make one other point which often gets forgotten. This law affects Indian industry as well. It's not a law that simply applies to foreign participation, right? Even though we are the most obvious, loudest complainers. What the DAE did essentially was that NPCIL indemnified Indian private suppliers through contractual agreements. And the problem really started at Kakrapar because after the civil liability legislation was passed, domestic Indian suppliers refused to supply components. And so NPCIL, through contractual agreements, essentially waived it. And the rationale that NPCIL used is actually highly suspect. I mean, it's never been tested in a law, in a court of law, so we don't know. But it is a highly suspect argument, which in essence said, well, you are manufacturing parts and components to our specifications. And so if there is a failure in the components, it's not your fault, it's our fault. And we can simply indemnify ourselves. right? Because we are the designers of the component. So, in essence, what they did, they used a very sort of circuitous logic to justify the indemnification that they did for private suppliers. Now, of course, because we are in a post 2010 environment, and the Americans, the Japanese, the French are now interested in getting into the Indian market. They are faced with this obstacle and therefore the pressure to amend the law. Now, in a very practical sense, yes, I think Raghu's right. The drivers of this pressure, are the United States. The United States is driving this, and it's driving this partly for political reasons, partly for economic reasons. And we can talk about that separately. But I would say that if you want to get foreign participation, you will have to amend the law. I don't see any way around it. Which brings me to the second question. Is there capacity on the supply side to meet the Indian demand? My honest answer to that is that today that capacity is whether we have that capacity is suspect. But the point is, everyone who's looking at this investment in India is looking at it over a very long time horizon. So it's not a question of do we have the industrial capacity to build 50 reactors today? The answer is no. But if you're talking of can the United States and essentially the Western industrial community assemble the capacities to build 50 reactors in India over a 50-year time frame, the answer is yes. But you can't get to that point unless you overcome this immediate obstacle. So I think Raghu is right in the sense that because Western nuclear suppliers essentially are responsive to market signals, they will build up their own internal capacities to meet market demand if demand presents itself. And right now, what we have is in the US, the first green shoots of increased demand because of AI, because of climate change, and so on and so forth. And the theory of the case is this that if this momentum for increased electricity continues, then even in the United States, we will have no alternative but to revisit nuclear energy as a source of supply. And then we come back to the question of will industry have the flexibility and the capacity to build up the supply chains required to sustain that demand? And my answer is yes, we can do it, but not if your time horizon is 5 years. If your time horizon is 25 years, yes, I think we have that capacity.
That comprehensively addressed these two issues. I think let me come to another issue which has sort of animated public discourse around private participation in India is that usually in most sectors, particularly critical sectors like energy production, nuclear energy, India has generally emphasized on technology transfer. In Russia's case, as you said, Rosatom, regardless, in Russia's case, much of the technology transfer has actually taken place. You could say that. Would that argument hold if it would, if India, as has been proposed, amends the Atomic Energy Act to allow for private participation without that? Because ultimately, nuclear energy production in general in most countries, I'm sure you would agree, would be viewed with a certain degree of security given its fallout from accidents, etc., and also would view it as a strategic interest where it would want to localize that sort of technology transfer. So do you think if India were to amend its laws to allow for private participation in the long horizon, as you are talking about, is that sort of technology transfer for, say, light water reactors or fast breeder reactors, or even the newer ones, the small modular reactors, which are being talked about for 55 megawatts, etc. Would India be able to achieve that technology transfer, let's say, in the not so distant future?
First, I have to underscore the point that this is a commercial question more than anything else, right? Because it's not just a question of what government demands. It's ultimately a question of if your suppliers are private entities, then their technology transfer decisions are going to be based on the metric of profitability. Do they come out ahead transferring technology or do they not? If they come out ahead transferring technology, they'll transfer technology. If they don't come out ahead, they're not going to transfer it. And government does not have compellence powers to force a private entity to transfer technology if it is unprofitable for them to do so. right? So I say this only because technology transfer will, in the first instance, be a commercial decision on the part of both supplier and the demandor. And that will have to be negotiated between companies like, say, Westinghouse and NPCIL, or Westinghouse and Adani, or whoever the players involved are. Two, the government will have a role because government will ultimately be, at least the US government will have a role because the US government will have a licensing process with respect to what technology transfer is permitted or not. Now, if you look at the historical record, say, for example, Westinghouse in China, the US government did permit Westinghouse to transfer certain technologies in their reactor design to the Chinese. In fact, it's the one decision that Westinghouse probably rues today because the AP1000, the technology for which was transferred to China, is now being cloned by the Chinese, and they are churning these out like sausages, right? And Westinghouse is, of course, now, sort of twiddling its thumbs, worried about its own viability. Um, so my expectation is that India will ask for technology transfer. It will probably not get technology transfer to the full extent of what it wants, but it will get some technology transfer consistent with the two constraints, which is company profitability or supplier profitability, and what at least the US government, where it comes to US companies, will want to protect either for national security reasons or for proliferation reasons. But let me correct you on one point, Kunal. I mean, even Rosatom has not done a complete transfer of technology with the VVR 1000 to India, right? What they have done is they've allowed India to build subcomponents to their design, which they are integrating in the reactor construction process. But there are many elements, especially in the hot section of the reactor, where they still maintain proprietary control. And this is actually less components. There are obviously components involved, but it has to do with advanced materials and the chemistry of certain things that go into the reactor and so on and so forth. So my sense is that this will not be a showstopper, that India and private companies in the West will negotiate arrangements for technology transfer. And the more avid entrants, like the newer companies, the guys who are involved in making SMRs, for example, the more avid entrants are actually more enthusiastic about technology transfer than the old majors who are involved in building traditional reactors. Because for them, it is an economic decision to transfer technology in order to get access to that market, in order to get economies of scale, and ultimately to increase profitability. So I think this will not be a serious problem. I mean, the bigger problems are the ones that Raghu flagged, right? First, high capital costs. How much money will India be able to actually plow into this enterprise over the timelines that we are talking of? That is a big issue. Second issue is going to be simply how effective the fabrication process is going to be, because the less effective the fabrication, the longer the delays in getting the reactor up and running. Longer the delays means the capital costs of the project increase, so on and so forth. So there are a whole series of issues that cannot be overlooked and dismissed. But I think those issues will have to be tackled subsequent to the entry of these companies. Right now, we have a situation where companies simply cannot enter, and therefore all the rest is academic. But even if companies can enter, those other issues are not going to be waved away, right? They're not going to disappear. So you're still going to have a lot of work to do before realizing, the Prime Minister's vision of 100 gigawatts of nuclear installed generating power by 2047.
Yeah, Kunal, let me come in on this.
Yes, yes.
I still go back to where I started, which is that I think a lot of this debate discussion is based on assumptions, hypotheticals, which I think may not realize. We think about the hypotheticals, we want to frame policies with regard to those hypotheticals, and then wait and see if the outcomes turn out the way we want. An analogy I will give you for this is India has been chasing transfer of technology and investment in defense technologies for the past 15 years,
Right.
apart
Or
from
maybe
our
even
old
longer.
Even
license
longer.
production and all that business. Okay. But now we sort of entered into this business of, we have gone through stage by stage, increasing the percentage of foreign FDI investment in defense. We started
Yes.
at 25%, went to 49%, now it's 74%, and 100% if you promise that it will be a completely revolutionary new technology that is going to be brought in. Nobody came and invested. No major foreign company came and invested because, as Ashley says, it's not in their interest to do so. Why will a major aircraft manufacturer come and give you all the technology so that you can make the aircraft tomorrow, which he today has a control over? So the logic of that situation was that he would come in to do some license production, he will do some co-production, he will do some subcontracting, he will do all that. But there's the key position where he holds some key elements of the technologies together, which he's not going to part with. Because that is not just a question of money, it's a question of you retain your position in dominating the value chain of that technology. And there's a value in that. You see that in chip production today.
Absolutely.
You
Yeah.
can give away
True.
a lot of
True.
stuff, but you will not give away the core technology of manufacturing chips and the foundries and the machines which work in those foundries. I think a similar logic is going to apply here. Linked to this is the issue that I am not yet convinced that there are these new technologies which are futuristic on small modular reactors, which India does not possess, which, if it comes into India, is going to transform the nuclear energy picture in this country. I'm not convinced on.
The argument is also being made that it's a fraction of investment that's required.
Yeah. So again, it just then comes down to money. Yeah. Uh, that instead of making 500 megawatt reactors, you will make 200 megawatt reactors, or maybe even 60 or 70 megawatt reactors. India has already also embarked on a similar thing. The budget speech of Nirmala last year has actually earmarked a fair amount of money for making 5 small reactors,
Small
which are
modular
based,
reactors. Yeah.
yeah, but which are based on the pressurized heavy water cycle that India is familiar with, and which it can then pursue. Then it's a question of whether you can attract investment to expand this or to scale it up, whether companies like L&T will mobilize investment for it because they will be partners in the production, etc. And interestingly, to the point that Ashley was talking about earlier, the Minister for Science and Technology, in a reply to Parliament last December, said we are expanding these, we are going to make provisions for entry of private players into the nuclear sector. They would invest equity, they would look after they would provide land, they would provide water, but the main operator would be the NPCIL, the state sector, who will then assume all the responsibilities of, because then he is regarded as the principal contractor while all the others are subcontractors. So you accept obviously the liability. It's like I make a car, there are 1,000 components being supplied by 1,000 people, but the automaker is the company which is responsible for the final product because he does all the quality testing and clearance and all that upstream before the products come in. And the minister emphasized that all this would be done under existing laws. Of course, maybe between that time, that was in December, and the budget and post budget speech, maybe there's some rethinking in the government about whether to make these amendments or not. I personally still feel that even if some amendments were made, and it is still an open question, what exactly you would amend, what kind of special provisions could be made to bring in, those are, I think, still matters to be discussed. Whether that will bring about a sea change and you'll get a queue of people coming in to invest, I don't really see that happening. maybe there is an open door in it. I still feel there are major technology constraints. There are still major supplier constraints, supplier capacity constraints. Let's not forget that even in the US, these small modular reactors have been slow to take off. There's
Yeah.
only one which is slowly coming up on stream. Even there, you've still got a supplier constraint. The plant is not up and running. It is just about got regulatory clearances. The technology is not stabilized. So we are looking at something which is quite a bit down the line. And in a parallel process, there are processes where BARC and NPCIL are also innovating in India. So I will once again say that I think we are anticipating that we are creating a big demand by removing this big constraint here, which will open the floodgates, which I don't think is really what is going to happen. So we are doing something very big in anticipation of something happening, which I think I'm not sure is going to happen.
May not fructify. Interesting point. Ashley, I think if I can come back to you on this particular small modular reactors, as Raghunandan pointed out, it's a relatively new technology, not just in India, globally. It's not quite tested, even in the US, where it's being attempted. It's still sort of almost prototype. Given that situation, and considering that India is a developing country, it still has several other commitments to its own people. It's one thing to say that liability for suppliers of these large reactors, as you were pointing out, Westinghouse and Arriva in France, Japan, etc. For them, the liability clause may, even let's say, if for them it appears really large, considering that they're established players, for the newer suppliers, would it not be fair to seek compensation because it's an untested technology? Would that be a fair argument to make?
No, I don't think so. But let me address that question directly because Raghu raised it, and it's an important question, right? Which is why is it that when it comes to nuclear technology, we are creating a regime which is essentially absolving suppliers of liability? I mean, that's
Right.
the heart of the question.
That's the heart of the question. Yeah.
I mean, we have to understand how this whole business came about. The Convention on Supplementary Compensation came about because it was an international effort to create an environment that was conducive for the expansion of nuclear power production. And people understood that nuclear technology has some inherent risk, right? It is a technology that, if you have an accident, could really have catastrophic consequences. And what they were trying to avoid was essentially a Bhopal-like situation where if you have supply liability, then you essentially go through the process of claiming damage through tort law. When you claim damage through tort law, you essentially go down the entire supply chain. And that is going to get bogged down not for years, but for decades in the courts. And the Bhopal example is a perfect example. Even to this day, people who have been injured as a result of that have not received, fair compensation. So what the Convention on Supplementary Compensation did was it came up with a different legal principle. And it said the purpose in the event of a nuclear accident is not to litigate who is responsible for the accident and how, but to rush compensation to those who have been affected. And therefore, what the convention did was it encoded two or three key principles. The first principle was if there is an accident, all liability is channeled to the operator. And the operator becomes responsible for managing the compensation process that followed in the aftermath of the accident. That was the first principle. The second principle was to create essentially a fund before an accident occurs. And the convention has a three-tiered fund. So there's a national fund, there's an international fund, and then there's a third tier fund, which we have not created as yet. But the idea was that you compensate people essentially through a pool of insurance. And then they did not absolve suppliers of liability. That's not quite accurate because supply liability is permitted if it is through the contract and if there are issues of willful misconduct. So, deliberate efforts to sabotage a system and create damage, right? So, under those conditions, what the convention allows is for you to have some measure of supply liability through contractual means. But you do not have an overarching principle of supply liability because their fear was that you would get bogged down into litigation before the victims of the accident could see even the first cent. And so the idea was you, and now again, there are some larger overarching assumptions in this model, right? What are those assumptions? At least two. One is that you're operating in an environment where there is adequate design review of the capabilities that you are designing and ultimately selling. Right? Because if you don't have adequate design review, then how can you hold a operator liable if the stuff that he's operating is ultimately junk? Right? So there's a presumption that there is a mature design review and regulatory system. Second, that there is a neutral regulatory authority that can enforce this process and is not linked organically to the operator or to the supplier. So again, there has to be a neutral authority. So there were these assumptions built in because this whole regime was created essentially from within Western, a Western social environment. So now what is the problem? The problem is no one is saying that you need to simply forgive suppliers if they are providing you with a patently defective product. The concern is less about penalizing suppliers in the event of an accident because the real victims have to be dealt with first, right? The suppliers, we can go after them at some point. But the important thing was to give the victims immediate relief. And so the regime was created precisely to give victims immediate relief through the affirmation of a principle that there would be no perpetual sort of challenges to suppliers because of defective products. So it was really meant to be a very pragmatic solution to a very serious challenge. And I think that is essentially what has now become the universal norm. That precisely because if you have a real nuclear accident, I can promise you, no matter what people say, the sovereign on whose territory the accident occurs is going to be the ultimate guarantor of protection for those victims, right? I mean, you can have all sorts of legal regimes. If you have an accident on your soil, your government is ultimately going to be responsible for providing, protection to the individuals involved. And so everyone understands this. The question was, how can you create a regime that allows them to pick from a pool of money that is readily available? And that's why you had this insurance pool, first tier sort of system, second tier compensation systems, and so on and so forth. Now, to answer quickly your question about SMRs, I think the problem is not the design immaturity of an SMR. The real issue, because many of these SMRs, right, have very advanced passive designs. And in fact, I know one SMR producer who has been so confident who says, I really don't care what the liability laws are. My design is so fail-safe that I'm prepared to go and invest in an environment even which has the most oppressive liability laws. Now, you don't have to take any of that at face value. But the point is this, right? SMRs have inherent advanced passive safety features, which make them less vulnerable to the kinds of Three Mile Island accidents that we had with large. But the problem that SMRs are going to face is less the question of technical maturity or technical effectiveness. The real problem is going to be economics. Because even if it is a small, into quotation marks, modular reactor, right? The capital costs are still going to be extremely high. So when you think about it this way, if I have to spend $1 billion on a SMR that is producing 300 megawatts or less, and I have to compare it to the capital costs of a 1 gigawatt reactor. Is the cost of the SMR going to be so disproportionately smaller that it makes it a natural choice? I don't know the answer to that. We don't know the answer to that because there is a big assumption built into SMRs. And the assumption is that we will manufacture SMRs assembly through an assembly line process. So the whole theory of the SMR is it's not going to be a bespoke product. I'm not going to build it in site. I'm going to build it in a factory. And I'm going to transport the components. So it's like the Ford motor car, right? I'm going to build these things in a factory. I'm going to ship the components to the site. I'm going to assemble on site, and that is going to reduce my costs. Let's put it this way. I have greater faith in the technology of SMRs than I'm persuaded about the assembly line model of manufacturing SMRs just yet.
The
So
economics of it.
we'll
Interesting.
wait and see. So I want to make
Yeah.
one last point before we break, right? The reason why we are circling around the whole liability question is not because untangling the liability mess gives us an open sesame door to nuclear energy. All we are doing is we are trying to remove what are the we are trying to fix the necessary conditions. It's not sufficient conditions. So even if you fix liability, there is every chance that Raghu's criticism on economics, on supply chain vulnerability, etc., will all conspire to prevent this from happening. The problem is we can't even test that unless we begin to say, let's get a more sensible liability regime. So even if we get this law fixed, all that we will have done is we will have created the necessary conditions for testing the proposition. But there is no guarantee that all this is going to add up at the end of the day to a magic solution that gives us energy independence.
Fantastic. I think I'll just take this last question to Raghu, taking a cue from your response, Ashley, which is really wonderful. As Ashley pointed out, India does have this ambition, and it is not just India. For climate reasons, every country seeks to reduce or decarbonize its energy sector. It's the largest carbon emitting sector in the world, and given that per capita energy consumption in India is going to be growing, it's in fact already the fastest growing in per capita energy consumption in the world. It appears that nuclear energy would, at least to some extent, we don't really know if this 100 gigawatt, whether it's really an achievable goal in the next 20 years, to some extent might mitigate the sort of carbon emissions that we're talking about and would in fact help. And with these small modular reactors, if we have this stumbling block of liability as an issue, would we not then risk not having it, let's say, commissioned in India? At least, even if you, as you're saying, even if it's just one or two, the fact that it could still happen, we're sort of foreclosing that option, aren't we?
I still feel that we are anticipating things which current experience tell us is very unlikely to happen. If you want to pursue a longer term increase in nuclear power, India has a fairly well established pathway to that through breeder reactors and the thorium cycle. In fact, I'll refer back to the response the minister gave in Parliament saying this is what India is committed to in terms of expansion of nuclear power. Now, if into that mix you want to add these new small modular reactors, and Ashley is absolutely right. The logic of the small modular reactors and why they are likely to be less expensive is that they are going to be built in a factory at scale in an assembly line, which assumes a certain volume of demand. You can't set up an assembly line based on somebody wanting one or somebody wanting two. You'll set up an assembly line if there's 100. If there's no 100, there's no assembly line. So we are building castles in the air in thinking about these things. So my argument would be, if at all you assume that this is the roadblock, let's see how many takers there are, discuss this in terms of where this is actually going, rather than assuming that things are going to happen. You make amendments to laws, and then what? Maybe one or two players come in and they take advantage of liberalized laws, and that's the end of the story. In which case, why should I have gone through the whole trouble of doing this? So, I personally think we are putting the cart before the horse. We don't know whether this technology is viable. We don't know whether it's proven. We don't know whether it's going to work any more than 500 megawatt plants, etc., which India is already doing, where money may be the only investment, may be the only obstacle. And let me add that many countries are going in for nuclear as a substitute for their former coal plants or their former natural gas plants or oil fired plants. Whereas the argument in most cases is you can supplement this with large scale investment in solar and wind linked with storage. And solutions to that is also coming on scale. They were slow to come on board. And compared to those, the costs of nuclear, any nuclear, including small nuclear, is still at least twice as much in nuclear as they are for solar and wind. So I don't see a compelling argument to push the proposal along those lines. And I would say, let's go slow. Why should I be rushed down that road when there are so many uncertainties clouding it, rather than assume that there's going to be a rosy future? So let me make this beginning and things will start happening.
Well, this has been a really lively discussion, and I think both of you have given such insightful replies and quite meaningful. And of course, this isn't the end of this conversation. It's going to,
Sure.
these committees have been formed, as you know, by the government. They are already discussing ways to amend the law. So it'll be interesting to see what comes off this renewed interest in nuclear energy generation here in India and globally. But for now, thank you so much, Dr. Ashley Tellis, joining us from Washington, D.C., and Raghunandan joining us from New Delhi, for making time for this week's Parley podcast.
Thank you.
I'm Kunal Shankar again. Bye for now.